Welcome to the Miami International Arbitration Society's webinar on online protocols for hearing. I'm Luis Onaten, Chair of MIAS, and I'm truly excited to hear today's webinar. The COVID pandemic has been many things, mostly terrible, but it has also been the catalyst for change. One change has been to bring the concept of online hearings in international arbitration from the rare occurrence to a regular part of our practice. Given the absence of universal guidance on the use of new technologies, a group of 6 international law firms, Herbert Smith, Asher, CMS, DLA Piper, Hogan Lovells, and Latham Watkins, have developed a protocol to deliver a globally consistent approach to the use of online case management platforms. You can tell this is a timely issue because right now we've started this webinar a little bit late due to technical problems. One of our speakers is having a problem getting into the platform. I'm sure this will be some of the things discussed. 2 of the firms that developed this protocol happen to be MIAS firms, DLA Piper and Hogan Lovells. We are lucky that 2 of the principal drafters of the protocol from those firms, Maria Scott of DLA and Michael Taylor of Hogan Lovells, have agreed to discuss the project, along with input from Eric Tuckman from the AAA. Leading the discussion will be my friend, Catherine Menendez de la Cuesta of Holland & Knight. She's a partner here in Miami, specializing in international arbitration. And without any further ado, Catherine, I'll turn it over to you. Thanks.
Thank you very much, Luis, and thank you to the Miami International Arbitration Society for having me. It is a pleasure to be here. As you mentioned, it is certainly a very timely discussion, and we have exceptional speakers to discuss the protocol with. I will start introducing you. We have Maria Scott, is a senior associate in DLA Piper's litigation and arbitration team. He's specialized in international arbitration. He's based in London, and she trained at DLA and has now been at the firm for nearly 8 years. We also have Michael Taylor. He's an associate at Hogan Lovells London International Arbitration Practice. He's also spent some time with the Paris arbitration team, and his practice covers a range of disputes, industry sectors, jurisdictions. He has a special focus on disputes involving Latin America and also Russia and the CIS. And Michael joined the working group that prepared this protocol in the summer of 2019. We will have with us also Eric Tuckman. He is trying to join us, as Luis explained, and he is, as you probably know, the General Counsel and Corporate Secretary of the American Arbitration Association. So thank you to all of you attendees for being here with us today. Thank you to our speakers, and let's start. The first question that I had for you, Michael and Maria, was what is this protocol and how did it come about?
Thank you, Catherine, and thank you, Luis, also for your kind introductions. And good afternoon, everyone, from a very, very warm and air conditioning free London. So apologies for what you're seeing. We're very hot over here. So just to answer Catherine's question, in around May of last year, as Luis has already said, 6 law firms got together to form a working group with the idea of considering how we might improve some of the processes that are involved in arbitration. And essentially the idea was to combine our experiences in order to improve and streamline some of those processes. So within the working group, we have a mix of different roles. We have fee earners like Michael and myself. We have process specialists, and we also have individuals who are involved in driving change and innovation. And it was actually those individuals who were instrumental in setting up this group, in reaching out to people that they knew and getting us all together in one room. And we were able to build on the collaborative way of working that already exists in arbitration, and many of you will be aware of this. So when it comes to dealing with the opposing side, parties and their legal teams are well used to having to cooperate with each other and collaborate to make sure that things go smoothly, particularly issues around the hearing, for example. And so obviously, as arbitration is a party-led process, some of these administrative and organisational matters have to be determined by the parties together for the benefit of both sides to ensure that practical and effective arrangements are put in place. And so as part of this process, we decided to prepare a guidance document dealing with the use of online case management platforms in international arbitration. And just briefly, what do we mean by an online case management platform? And essentially, this is software that enables participants to store, access, manage, edit documents, essentially the case file, throughout the life of an arbitration in a single shared repository, and access to that repository is governed by different levels of permission. And they also enable participants to, and in fact tribunals, to comply with their obligations to store data securely. And so we put together a protocol which is around 40 pages long. It contains a number of different features and sections, including, for example, a list of must-have criteria, which we say these platforms ideally should offer, and nice-to-have criteria. And if we have some time, I'll go into that in a bit more detail a bit later. There's a checklist for parties to use when they're considering this kind of software. There's a questionnaire that they can use in their discussions with technology providers. There's draft wording for a procedural order, should that be of any use. And given that we recognise, that we want this protocol to be well used and well received by the arbitration community, as part of our process, we sought feedback from some of the global major arbitration institutions, and they gave us their input. That included individuals such as Eric, and I think he'll touch on his feedback a bit later. And this protocol is now available online. You can access it on a web page. I can give the details for that if that's helpful later. And we're in a period of public consultation, during which we're inviting feedback from anyone, either on the web page itself through a form or to any of the individual members of the working group. We'll then review that, revise the protocol with a view to publishing it, an updated version, later in the year. I don't know, Michael, if you want to add anything?
Yeah, thanks, Maria. And before I start, thank you to Louise for the introduction, to Catherine as well, and to everyone who's joined us. I think I will plan to touch on why we thought that this was an important issue to deal with as a group. Maria's obviously helpfully touched on how we came together and the process that went into this. Essentially, as many of you will be aware, arbitration is extremely global, and you can have parties, counsel, arbitrators located in very different jurisdictions. And so technology has always been something that's been important in arbitration to make sure that we can keep in touch with our clients, prepare our cases, liaise with the tribunal, and so on. And because of this, and as increasingly technology improves, parties and arbitral participants are always looking for ways to become more time and cost efficient in their use of technology. And the protocol is really a further development along that path. We've touched on case management platforms, and we recognize that these can really drive time and cost efficiencies throughout the arbitral process. But the problem that we found talking to each other was that a lot of the time, either they're not used at all, or they're only used in a really disparate fashion. So you might use them for certain bits of the arbitral process, but not for others. And when parties are putting these together, they're normally doing it from scratch. They're doing it ad hoc, based on potentially a case they've done before, or what they think they might need for this particular purpose. So what we sought to do through the protocol, is we thought this is a real opportunity to not bring conformity to the arbitral process, but to really help parties with increasing their efficiencies, reducing costs, and making sure that we can conduct arbitration in kind of the most practical way possible. And, you know, obviously I mentioned time and cost efficiencies a fair bit. That's not the only driver. There are a few others. And I think one that I'll touch on now is security. And obviously, often a lot of us deal with some very sensitive materials, and for every client, every matter, every dispute is very potentially have a big impact on them if there were any breaches of that security and sensitive documents were leaked. Now, we know that law firms and clients have spent huge amounts of money and are really focused on ensuring that their platforms, their document storage is all very secure. But security is only as strong as your weakest link. And what we found speaking together is so many of us have had experiences where one of the parties, without naming names, sometimes arbitrators, have used platforms that are considered to be less than secure, so potentially a Hotmail account or a Gmail account. And we thought that by encouraging and helping parties use case management platforms, that could really be a way of resolving that problem and trying to ensure that clients had real confidence in the security of an arbitral process.
Excellent. Eric, you, from your perspective, and because of the role you play with the AAA, what are the challenges that you can tell us that the international arbitration community faces with the online management of arbitrations and disputes?
Well, there are, in fact, a number of challenges, but I do feel as though before we speak about what those are, it's important to note that they can be overcome. And so virtual hearings, online platforms, technology, its integration with international arbitration is something that we all have to address and accommodate. And I think that really at the outset, one of the biggest challenges is that this is a new skill set. It's new technology. It's new an understanding of how things work. It's just like any other issues. It's not a legal issue, but it's understanding how you actually conduct hearings online, how you can interact with the tribunal when you're not in the same room. If you're representing a party, how do you huddle? How do you discuss? How do you communicate with parties? You know, with your colleagues, with the persons you're representing. So a challenge is really just understanding how the process works and makes it work. And so with COVID, we've seen, and this is something that AAA and ICDR spent a bit of time on pretty quickly. It's developing standards, processes, enabling training staff on how the different online platforms work, gaining that expertise. It's not just a matter of coming into the process and saying, just tell me what to do. Everybody is going to have to know how to deal with problems, as I had today, getting online, you know, for whatever reason, the links aren't working. Is there a conflict? Is the camera not working? It's none of that, but you have to be able to work through all those things. You have to be able to, you know, on your own with the resources you have to be able to use the technology that exists to make the arbitration process work. Some of the other challenges have already even been touched on, but privacy, security are critical. Some of these are legal issues. They're imposed. You've got to be able to handle data and information that might be contained online in a way that's consistent with what's legally required. But there's also huge variation in party expectations regarding privacy and security. Frankly, in our experience, in some cases, it's absolutely critical. It's very important. What is going to be presented and discussed is highly confidential. In other cases, and this isn't to diminish the importance of confidentiality, or of legal requirements that some parties are not as concerned about it as much. They're not as concerned about the materials that might be going across the internet by email. But again, it's an issue. It's another layer of complication. I talked about some of the challenges regarding how you interact, how you present a case, how you, as a tribunal, how you can speak to each other while a case is proceeding, how you can break, how you ensure that one party isn't hearing something that the other party doesn't intend them to hear. So all those protocols have to be addressed as well. And then the term "the weakest link," was just mentioned as well, and that is a critical challenge as also. You have many parties, different parts of the world, different levels of sophistication, and that needs to be harmonized, because if one person isn't paying attention, if one party is not setting their privacy settings the right way, if they're not aware of the requirements that exist regarding how data should be maintained, then that person is vulnerable, and it can upset the entire process. So that gets to everybody needing to understand, being trained, and making this part of your skill set as a lawyer or as an arbitrator, as an advocate, or as a party.
Let me, Eric, ask you a follow-up question on that. So, as I understand it, one of the challenges is the fact that there are different players here, and there are different concerns, different requirements, different training, experience probably dealing with electronic and IT devices and tools. How, as an institution, how do you deal with this? How do you try to, put everyone on the same page, make sure everyone can access whatever tools you provide, that everyone is aware of the importance of safety and security, and to address the challenge that you mentioned of having different players?
Yeah, so just to address at least how the AAA ICDR is handled, really about 2 years ago, we started putting, even prior to that, but we put considerable resources into technology and infrastructure. We have a security team that meets once a week. It's the CIO. I'm a member of that committee. A member of the HR, senior member of the HR department. All other people from our IS department, all meeting and talking about what's the status of our systems, what's changing, what do we need to implement. In terms of our interface, though, with parties that are involved in cases that we're administering, we've seen a little bit of it. This is another challenge, which is that in many respects, the technology, what we want to offer, or in some cases impose in terms of requirements, they simply weren't being adopted by the parties. In other words, we could tell everybody that they're required to have the case administered by the AAA ICDR, and that the case is going to be essentially the platform, our web file platform will be the repository for all documents, all exchanges. The fact is, most parties would pretty quickly, particularly a couple of years ago, they simply would have opted out of it. They would have said, and they did say, for this case, we're comfortable with our email exchanges. And so while we push and push and push, and again, the next level of our process is we're making web file much more robust to enable parties to capture more information, more types of communications, control who sees what. Parties can grant permissions as opposed to just us. So we've tried to be both assertive and aggressive, but also recognize, this concept of party autonomy actually comes up in the draft protocol. But ultimately, when it gets right down to it, when the parties and the tribunal agree to modifications that go one way or another, you're going to have to, as an institution, live with that a little bit. that's going to change because, frankly, there will be liability issues if we're not following best practices. There will be expectations. One of the benefits of the protocols is that it sets a set of standards. It's a bunch of leading firms, leading international arbitration practices saying, this is the consensus as to what we think is appropriate for a platform. And that's a powerful statement about then what we can say to parties we think is an appropriate platform for them to adopt, which will mirror what we have. So hopefully that's responsive, but it's a complicated question with a complicated answer.
It's very useful and very interesting. Thank you. And now we've seen challenges, Maria and Michael. Now, what do you try to accomplish with this protocol? What's the goal?
So
Michael, do you want to start?
I'll jump in on. Yeah, I'll jump in on that one. I think there are a number of goals, but I would say that from my perspective, and Maria can obviously add her take on this, there are 3 that I would highlight. The first for me is sort of as we touched on earlier, we want the protocol to serve as a starting point for parties deciding whether to choose an online case management platform to manage, share, store data throughout the course of an arbitration. And in the event that they would, in the event that they and their clients think that would be helpful, which obviously we would argue that it is, how do they go about doing that? How do they navigate the various technological aspects of it? How do they make sure that they're thinking of the right issues and asking the right questions when they're setting this up? It can be so hard to plan ahead in an arbitration. The various procedural steps, but sometimes it's difficult to think of the issues that might come up in 18 months' time or however long it may last. The second is that, and it sounds quite simple, wanting these conversations to happen at the very outset of the arbitration. As I touched on before, sometimes these platforms are set up ad hoc, and that can be because everyone's so busy getting to grips with a case that they don't think about this, and later on they go, oh, we might need something, let's put it in. But actually these conversations are easier and better to have right at the start. And finally, and importantly, obviously we've talked about how we came up with a protocol and what we think would be helpful, but from a tech provider's perspective, they need to understand exactly what's needed as part of an end-to-end solution, and that's where hopefully this protocol helps. And obviously there'll be some gradual development as they see more and more cases. That's what I mean. Those are my kind of 3 takeaways. But Maria, I don't know if you've got any additional points you want to mention.
Thanks. Well, yeah, I agree with everything Michael's just said. I think I'd just add that it's very much our intention for this protocol to be of universal assistance, regardless of the location of the arbitration, the rules that apply, or whether it's ad hoc, whether it's a small case, whether it's a large case. And you'll see that if you look at the protocol, and Eric's already touched on it, this idea of party autonomy, but also flexibility and taking these suggestions on a case-by-case basis for what will be relevant and appropriate for that specific case. So one of the things that we're aware of is that many of us in the working group are actually based in the UK, but that was just an accident of how it was set up, and it's not in any way intended to be a UK or a London project that only applies in the UK. And we're, one of the things we're really grateful for today is we're speaking to people who practice in North America, and that's part of this. We want this to work for everyone. So yeah, that's what I just add.
Eric, you told us about the challenges, and my next question to you is, how is this protocol going to help to address them?
I mentioned, in some respects, I think that one of the greatest benefits is that it is a very detailed document which reflects what the community, as of this moment, expects and looks for and anticipates in a platform that will serve to support the international arbitration process. So it essentially provides a roadmap. It provides a statement about what the expectations are. So again, as an institution, that's helpful because we feel as though in some respects there has been a little bit of delay in the response to technology. The legal field is conservative. Just look at the way hearings traditionally, whether it's arbitration or litigation, no matter where in the world you are, it generally involves a practice that doesn't look all that different than it did decades ago. So it reflects, I think, a huge advancement in where we are. Right? Collectively, this is where the international arbitration community is. And so both as a statement and also in the detail it provides, it's very, very helpful. So that's just one overall observation, just what it stands for, who it came from, and the content of it is helpful and significant in that way. Again, I think also it helps us by showing that this is technological advancements and also issues and concerns about security are here to stay. You won't be moving back. Institutional perspectives, again, I think these also sometimes convert easily to being viewed as another aspect of a challenge. But another perspective is that the protocols that exist right now, it's current, it's forward-looking, but I think we can fairly say that in 1 or 2 years, despite all the work that went into it, it would probably be written a little bit differently. So this is very much a moving target. It involves topics that change pretty rapidly. So again, we need to stay on top of that as well. And so I just also think that in terms of our view, this does provide a little bit of pressure. It puts pressure on all of us in the field to make sure that we are current and up to speed and knowledgeable about all these things. I would add, the protocol provides a list of must-haves, nice-haves in terms of what a platform would look like, and it is it describes a pretty robust, fulsome system that would be all things to all people. I think that will be a challenge. I think some of the things on the must-haves list will really be difficult. And each institution, I can tell you again, we've put quite a bit of money and time and resources into our platform. Other institutions have different platforms. They've been built for their case management systems. Other institutions frankly don't have a platform at all. That's an issue that I know exists and that you all at least considered. Some cases go ad hoc. Where do they go for a platform? There's different options there. But in the future, perhaps there's some convergence. But for the time being also, I think we are going to have different systems with each institution or company that's building a platform on their own as perhaps a business opportunity, developing things just simply in the way they see fit for where we are now.
Yes, and to follow on that point, and switch now to Maria and Michael, a very important thing to keep the protocol current and updated is to know what the arbitral community thinks. And I know you've received feedback and are considering feedback. I think, Maria, you mentioned that the project now is open to public consultations. So I wanted to ask you a little bit about this process, how it's going, what type of feedback you're receiving, how do you consider it, how you implement it and include it?
So I would say that the feedback, luckily reflects Eric's view. Everyone that has provided me directly with feedback or to the working group, as far as I'm aware, it's been very broadly positive. I think everyone recognizes the benefits of having a protocol like this, having guidance like this, and the need to innovating and adapting in the sort of technology space. And one, recurring theme is that this is obviously very timely, because as Luis touched upon in his introduction, the unforeseen coronavirus issues that we're all facing mean that while we were doing it before, everyone's really accelerated their thinking in, okay, well, how do we best use technology? How do we use it most efficiently? How do we extract the most out of it? And I think that will be a conversation that keeps going beyond, hopefully soon, the end of the kind of nightmare that we're going through. So, as I said, broadly positive. I think one question, and Eric sort of touched on it, is people use different providers, and there have been questions about how, for example, how willing people may be to set up a brand new platform with a different provider or others. But while that will be a challenge, and that's something we'll have to work through, I think there is flexibility inherent in the protocol, which allows everyone to use a case management platform to coexist with their other platforms, and which will allow everyone to build a platform that suits their clients' needs, their needs of the case. And so I think while we have a long list of must-haves, nice-to-haves, I think there is plenty of scope for us to work around existing technology that's out there.
Maria, I don't know if you're going to add something.
I was just going to add that the feedback that I've had is very similar. I think people accept that this is, this protocol reflects a step in the right direction when it comes to identifying this as an issue and something that we all should be turning our minds to. And I know from the information that the working group have shared that so far the protocol has been viewed and accessed from over 90 countries. So hopefully, people are aware of this and they're taking it on board.
Until when is this open to public consultations? What's your timeline, more or less?
So it's we're saying at the end of August. It's not exactly set in stone, but that's what we're aiming for.
Have you received any, I don't want to say criticism, but something that people would change, or something you are considering maybe to change a little bit, or it's mostly supportive of the work you've done?
I'd say it's mostly supportive. I think we've had some queries about, how it's intended to operate, and I think actually both Michael and Eric have touched on this, particularly the lists of must-have and nice-to-have criteria.
Right.
And one thing that we sought to make sure that is clear in the draft is that, this is an aspirational list. We're not promising that there is a product in the market that ticks all these boxes. We're also not saying that there needs to be for every case. And each case is different, and it's sort of a balancing exercise of what's required and what's appropriate and what's cost efficient. And so, going back to Michael's point, this is really a starting point. And so I think we've had some conversations where that back and forth is, that explanation's been given, and that's made things, it's been helpful for us to have explained that more up front as well.
I think one good thing about the protocol among many is that you explain why. And I think, we can all decide, users, clients, arbitrators, when it's appropriate to use one or the other, because you say the reasons behind a specific guideline or recommendation. And then also, if we don't find a provider that checks all the boxes, at least try to get there knowing why.
Exactly.
Eric, you provided feedback, and I don't know if you can tell us a little bit what the feedback was about, or at least what you focused on.
Yeah, Catherine, that was my question, right? You were asking me? Yeah.
Yes.
So we, I think perhaps one issue we would provide feedback is this one that was just mentioned. Many of the issues on the must-have list, certifications, it's a very, very elaborate system that would be designed. Something that checks all those boxes might be difficult to build, quite frankly. There are aspects of it we can do. I think in many respects, nothing on there was a surprise, but I think it might be a little bit overly restrictive. You're going to find that there simply aren't many platforms that have all of those things. So perhaps some things drop down to the nice to have list. That's I think one issue. I think also just the description perhaps of the protocol and how that's going to evolve is something that needs some thought. So parties, lawyers, arbitrators, where would you start today when you think about selecting a platform? It's probably not all that easy. If it's administered, decisions going to be made for you largely. But how often do parties and arbitrators really ask about the platform? So the protocol provides a pretty extensive list of questions that people should think about. So again, I think that's pretty forward thinking. I don't think that's where people are right now. And so I think it might be helpful to indicate a little bit more about where we are in that whole process about developing a platform. A lot of people say if there's just one platform that would resolve all the problems. I think it's going to be a while before there is even a handful of platforms that the community is going to know about and rely on. That's going to take some time.
I would like now to move a little bit more to a substantive perspective. And I don't know if you, Michael, and Maria can pick, we can start with you, Maria, something substantive, some guideline that you included in the protocol and you can comment or highlight for us today.
Sure. So actually we've touched on it quite a bit just organically. So that's good to know that it's a topic of interest. And that is this distinction between the two sets of criteria. So on the one hand, the capabilities we've called must have. So they're sort of the ones that are identified that a platform might have by default. And then the nice to have would be like added functionality that might benefit the parties in a particular case. And as I've said, even though they're divided into those two camps, the fact that a platform might not tick all the must have boxes, it doesn't mean it's not an option. And we have tried to make that clear. But maybe I can just sort of give some examples of the types of criteria to make this a bit more concrete for people. So, for example, as a must-have, one of the key criteria for us is data security. But what we've tried to do, instead of just saying, data should be secure, which is kind of a lofty statement and perhaps not all that helpful, is we've tried to give some sort of concrete guidance. So, we say the data should be encrypted. We say that certain cybersecurity standards should be considered or complied with. So, and that goes back to Michael's point about it's meant to be practical and of actual real use. Other criteria are, the kind of permissions that are available. Can you set a permission how you access a document? Can one person access everything, or can you really be in control of that? Each team has a separate workspace. I think that's accepted to be the norm. So one party or the tribunal can organize and annotate their documents and no one else can see them. So those are the kinds of criteria that we were thinking of as your sort of baseline criteria. And then if you think of some added functionality that you might want to have if it's appropriate for your case, so things like, is there an e-bundling option? Can you literally press a button and create your hearing bundle? I know for many cases that could really be quite attractive, but equally it's not It's not something that means, oh, we can't use this platform because it doesn't offer that. Or something like, does the platform integrate with other software that you're using? So if a party's using an exhibit management software or analytics tools, it might be attractive for them to be able to integrate the two. So those are the kinds of criteria, and hopefully that was a helpful sort of overview of what we were thinking there.
Absolutely. Thank you. Michael, is there any guideline that you would highlight?
Thanks, Kathy. I think, again, Maria obviously holds in ones, and it's great. She says that those are coming up organically. I think the only other ones I would select, again have come up organically, so that's positive, is the list of issues for people to think about, which is set out Annex 3 of the protocol, and then the questionnaire to technology providers, which is at Annex 4. And I won't go into them in huge detail, but their aim is to provide a broad series of issues that may come up from the start of the arbitration to the end, that allows parties to build a case management platform that really suits them and the case they're involved with. So, as an example, issues of jurisdiction, what requirements are there for data protection in, where the client may be based, where the legal counsel may be based, where the arbitrator may be based. Do sanctions apply? Because, depending on which country you're dealing with, there may be sanctions imposed. And going, that kind of thing at the beginning of an arbitration, right through to the end of, okay, well, what, at the conclusion of the arbitration, what use are we going to have for this platform? Right across the way. And the questionnaire itself, that for me is a really good way of ensuring, sort of dealing with some of the issues Eric talks about, in that you can build your own questionnaire, but this is obviously a guide, and you can rank scores depending on answers, and that really allows you to create a sort of a platform that suits you, suits your client's needs, and ensures that there is flexibility, which is, I know, the word we've talked about a lot, but that's really important. Is we want everyone to be flexible. We don't want anyone to feel that this protocol is this is what you must do, sort of guide or set of rules. It's really, it keeps the inherent flexibility in arbitration that we all really like.
Great. We are going now to address some of the questions that we've received. We have several. So the first one is an easy one. It's, how do we get a copy of the protocol? And I think, Maria and Michael, what I did is I Googled the name of the protocol exactly, and I obtained a copy. I don't know if you can tell us a little bit more of how to obtain it, if it's an easier way.
I mean, I'm thrilled that worked. That's always good to know that your Google search words are working.
Okay.
Yeah, I mean, I can read the very simple web address. It's protocol.techinarbitration.com. So if that's helpful to anyone, but equally Google. Yeah.
Great. That's what I didn't remember if there was a specific website. And is it true that right there people can submit feedback? If someone wants to use this public consultations round, how do we do it?
Yeah, so the webpage has an online form similar to many you'll have seen before for fun things like complaints, but this one is not, hopefully, complaints. But equally, there's a list of all the members of the working group in the front of the protocol, and all of us would be happy to receive feedback if that feels more appropriate.
Another question is, one challenge is ensuring that enhanced use of technology will create an even less level playing field. Access to technology, connectivity, data. What are your thoughts on that?
That's a valid question. So technology requires, we discussed training, skill, practice, resources, And so I guess organizations and individuals with those resources perhaps will be better situated to quickly come up to speed. That might be an issue, something to be concerned about. I do think, though, the alternative, again, is what we've been doing for a while. It's in-person hearings, international arbitration. That means also resources traveling. And so in some respects, I think it may provide more of a leveling in terms of the playing field. Organizations, individuals with less resources still will hopefully relatively easily be able to participate in the process in a meaningful way. And again, if the platform is set up in a way that if parties present their case, they present their case, that should be the same for everyone. I think it also provides some opportunity in terms of the selection of arbitrators. It'll be easier to select arbitrators from other parts of the world that might otherwise have been less represented in the arbitration process because it'll be virtual. And so again, the resources need to do that, to travel won't be as much. So I think there are both concerns, but also some opportunities there.
Absolutely. Another question we received is, does the protocol deal with the issue of whether a witness is being coached by someone in the room that can't be seen?
No, so it as far, Maria can correct me if I'm wrong, but no, it doesn't deal with that particular issue. What it is aimed at is ensuring that there is, documents are stored correctly and so on, and there's an easy exchange of documents. One way that you can deal with it there, and it's touched on in the protocol, is that if you want to ensure that a witness only has access to particular materials, then you can set, as one of the kind of things we want to ensure is that you can set limits on what particular individuals have access to within particular folders, and obviously it will be between the parties to agree exactly how to measure what a particular witness can have access to at particular times as well. But there's nothing in there that deals with specifically what should happen when a witness is giving evidence.
Yeah, I think I just add, completely agree with that, that the virtual hearings or online hearings options were something that we discussed when we were talking, but we decided to focus our discussions on the sort of case file document management side of things. On the one hand, because trying to do both was almost a little bit too big of an issue to try and deal with it in one go, and also with the benefit of hindsight, I realized that since the pandemic, many of the institutions have published their own guidance on how to conduct those kind of hearings. So actually it might have been an overlap there. So there is guidance out there on the hearings. It's just not in this protocol.
Understood. We're running out of time, so I'm going to choose a couple more questions and we'll finish. One, I think, Hope Easy is for you, Eric. How many online arbitrations has the AAA or the ICDR administered? I don't know if you know the number by heart. Or
they
maybe
are,
recently.
Yeah, I should have that number. And actually, during our last team meeting, I said we need to have that definitive number because we're going to be asked soon. There are many hearings that are starting to take place online. That's a general answer, but this includes things like preliminary conference calls, organizational calls that frankly used to be done by conference call. Now they're on Zoom. Now they're some sort of face-to-face interaction. So that's interesting. And in terms of numbers of hearings, actual merits hearings, those are really starting to ramp up. I just don't have the specific number. Domestically, hundreds of cases are being conducted virtually. Numbers getting, again, quite large. And we're just sort of at that time now where when the pandemic broke, everybody said, let's wait to the fall. Let's see, postpone hearings till then. Well, it's the fall, things haven't changed. And so parties and tribunals are looking at the reality that really they're going to have to consider online hearings or postpone for perhaps quite some time. So they're really ramping up at this point. And we're going to have some specific numbers soon because we know this is of interest.
Great. Excellent. Well, I think we to respect everyone's time, it's best to finish our conversation now. It was a pleasure, and I think Luis is going to join us. Great, Luis. Thank you very much to all of you and to MIAS again.
Well, again, I want to thank Catherine. Great job moderating. Michael and Maria, thank you. I thank you, Eric. With respect to Michael and Maria, I'm not going to say who, but I got one of the partners from your firm saying, how great it is that you guys are being able to do this, and you're really the right people to do it because people like me would have no way of understanding the technology. So I really appreciate you guys doing it. And the truth is, this is, just to see how timely this is. During this webinar, I got an email from the LCIA talking about, with new rules, 19.2 providing for virtual hearings, either by conference call, teleconference, or new technologies. So this is very timely. I really appreciate it. Hopefully people have comments. You said where to send those comments. And this is something that's going to be affecting us for the long haul. Eric was telling the increasing number of hearings. I had a hearing, as an arbitrator, which, yes, we first tried to postpone. We didn't, things didn't change, and we finally said it, and we had a 3-day hearing. This is here to stay. So anyway, I thank everyone for joining us. Stay tuned to the next MIAS webinar. And again, I appreciate everyone joining us. Have a great day.